Section 3 Parental Authority. Subsection 1 General Provisions. Article 909, Custodian. 1. Parents shall have the parental authority of their minor child. In cases of an adopted child, the adoptive parents shall have the parental authority. Less than amended by Act No. 7427, March 31, 2005. Greater than. 2. The parental authority shall be jointly exercised by both parents during their marriage. If the parents fail to reach an agreement, the family court shall determine it upon the request of the parties. 3. When one parent is unable to exercise the parental authority, the other shall exercise it. 4. If a child born out of wedlock is legally recognized and his parents are to be divorced, the custodian shall be determined by an agreement between the parents, and, if such agreement cannot or would not be made, the family court shall designate the custodian upon the request of the parties or ex officio, provided that if the agreement between the parents harms children's welfare, the family court shall order to correct it or ex officio decide the custodian. Less than amended by Act No. 7427, March 31, 2005, Act No. 8720, December 21, 2007. Greater than. 5. In cases of the annulment of marriage, judicial divorce, or action demanding affiliation, the family court shall ex officio determine the custodian. Less than amended by Act No. 7427, March 31, 2005. Greater than. 6. The family court may, if deemed necessary for the welfare of a child, alter the person of the parental authority to the other party upon request of a relative of the child within the fourth degree of relationship. Less than newly inserted by Act No. 7427, March 31, 2005. Greater than. This article wholly amended by Act No. 4199, January 13, 1990. Article 909-2, Designation, etc. of person of parental authority. 1. If a parent designated as the sole person of parental authority under Article 909, 4 through 6, has died, the surviving father or mother, the minor, or any of the minor's relatives may request the family court to designate the surviving father or mother as a person of parental authority, within 1 month after becoming aware of such fact or within 6 months from the date of death. 2. If the adoption has been annulled or dissolved, or if both adoptive parents have died, one or both natural parents, the minor, or any of the minor's relatives may request the family court to designate one or both natural parents as a person or persons of parental authority, within 1 month after becoming aware of such fact or within 6 months from the date on which the adoption has been annulled or dissolved or both adoptive parents have died, provided that the same shall not apply where both adoptive parents of the fully adopted child have died. 3. If no request for designation of a person of parental authority has been made within the period prescribed in paragraph 1 or 2, the family court may appoint a guardian of the minor either ex officio or upon the application of the minor, any of the minor's relatives, an interested person, a public prosecutor or the head of a local government. In such cases, she shall be given an opportunity to state her opinions unless the whereabouts of the surviving father or mother or one or both natural parents are unknown or where she fails to respond to a summons without any justifiable ground. 4. The family court may reject the request for designation of a person of parental authority under paragraph 1 or 2, or for appointment of a guardian under paragraph 3, if such request is deemed inappropriate for the welfare of the minor, taking into consideration the intent and competence of the surviving father or mother or one or both natural parents for fostering the minor, motives of such request, intent of the minor and other circumstances. In such cases, the family court may appoint ex officio a guardian of the minor or designate the surviving father or mother or one or both natural parents as a person or persons of parental authority. 5. The family court may appoint a person to perform the duties of the person of parental authority or guardian of the minor until the person of parental authority is designated or the guardian of the minor is appointed under paragraph 1 through 4, either ex officio or upon the application of the minor, any of the minor's relatives, an interested person, a public prosecutor or the head of a local government in any of the following circumstances. In such cases, Articles 25 and 954 shall apply mutatis mutandis to a person to perform such duties. 1. Where a sole person of parental authority has died. 2. Where the adoption has been annulled or dissolved. 3. Where both adoptive parents have died. 6. Even if the guardian of a minor has been appointed under paragraph 3 or 4, the family court may terminate the guardianship upon the application of the surviving father or mother, one or both natural parents, or the minor, if necessary for the welfare of the minor, taking into consideration the situation of the minor's fostering, the changes in the competence for fostering the minor after the appointment of the guardian of the minor, the intent of the minor, and other circumstances, and designate the surviving father or mother or one or both natural parents as a person or persons of parental authority. This article newly inserted by Act No. 10645, May 19, 2011. Article 910. Exercise of child's parental authority. A person of parental authority shall exercise, in place of the child subject to his or her parental authority over children of such child. Less than amended by Act No. 7427, March 31, 2005. Greater than. Article 911. Legal representative of minor child. The parent who exercises parental authority shall become the legal representative of his or her minor child. Article 912. Exercise of parental authority and standards for designation of person of parental authority. 1. In exercising parental authority, priority shall be given to the welfare of a child. 2. In designating a person of parental authority, the family court shall give priority to the welfare of a child. For such purpose, the family court may seek counsel from experts in the related fields or social welfare agencies. Less than newly inserted by Act No. 10645, May 19, 2011. Greater than. This article newly inserted by Act No. 7427, March 31, 2005. Subsection 2. Effect of parental authority. Article 913. Rights and duties to protect and educate child. A person of parental authority shall have rights and duties to protect and educate his or her child. Article 914. Right to designate place of residence. A child shall reside at a place designated by a person of parental authority. Article 915. Right to take disciplinary action. The person of parental authority may, in order to protect or educate his or her child, take necessary disciplinary action against the child, and may entrust such child to a reformatory or correctional institution upon the approval of the court. Article 916. Child's peculiar property and management thereof. Any property acquired under the name of a child shall be peculiar property of the child, and such property shall be managed by the person of parental authority who is the legal representative of the child. Article 917 deleted. Less than by Act No. 4199, January 13, 1990. Greater than. Article 918. Management of property gifted to child by third party. 1. If a third party, in gifting a property to a child, has declared an intention to oppose the management of the property by the person of parental authority, the person of parental authority shall not manage the property. 2. If, in case of paragraph 1, the third party has not designated a manager for the property, the court will appoint a manager upon the application of the child to whom the property has been gifted, or of any of its relatives pursuant to the provisions of Article 777. 3. The same shall apply as prescribed in the preceding paragraph if, where the authority of the manager designated by the third party has been terminated, or if it becomes necessary to change manager, but the third party fails to appoint a new manager. 4. The provisions of Article 24, 1, 2, and 4 former part of Article 25 and Article 26, 1 and 2, shall apply mutatis mutandis to the cases of paragraphs 2 and 3. Article 919, mutatis mutandis application of provisions concerning mandate. The provisions of Articles 691 and 692 shall apply mutatis mutandis to the cases of property management as provided in Articles 916, 917, and 918. Article 920. Right of representation by person of parental authority with respect to child's property. The person of parental authority who is the legal representative of the child shall represent the child on juristic acts concerning the property of the child, provided that if an obligation is to be assumed requires any act of the child, the consent of the child itself shall be obtained. Article 920-2. Effect of act done under joint names by one of persons of joint parental authority. If both parents have parental authority, and one parent, under the names of both parents, represents its child or consents to a juristic act of the child, such representation or consent shall be valid even though it is contrary to the intention of the other parent except for the case where the other party is in bad faith. This article newly inserted by Act No. 4199, January 13, 1990. Article 921. Acts of conflicting interest between person of parental authority and child, or among children. 1. If a person of parental authority, who is the legal representative of a child, is to perform acts of conflicting interest between himself or herself and his or her child, he or she shall apply to the court for appointment of a special representative on behalf of the child. 2. Where a person of parental authority, who is the legal representative of children, is to perform acts in which the interests of one child conflict with those of the other child or children, the person of parental authority shall, on behalf of one party, apply to the court for appointment of a special representative. Less than amended by Act No. 7427, March 31, 2005. Greater than. Article 922. Duty of person of parental authority to pay due care and diligence. If a person of parental authority exercises the right of representation on juristic acts or the right of property management for the children under his or her parental authority, he or she shall exercise such authority with the same care and diligence as he or she would do so on any acts regarding his or her own property. Article 923. Account of property management. 1. When the parental authority of a person who is the legal representative of a child has been extinguished, the person who has been exercising parental authority shall render an account of the property management of the child. 2. In case of paragraph 1, the benefits accrued from the child's property shall be deemed to have been set off against the expenses from bringing up the child and from managing the property, provided that this shall not apply to a property with which a third party, in gifting it to the child, has declared an intention contrary to such set off. Subsection 3. Loss of parental authority. Article 924. Adjudication on loss of parental authority. If a parent abuses parental authority or is guilty of gross misconduct, or there exists any other serious reason for not allowing the parent to exercise parental authority, the court may, upon the application of any of the child's relatives pursuant to the provisions of Article 777 or of a public prosecutor, adjudge the loss of parental authority. Article 925. Adjudication on loss of rights to representation in property management. If a person of parental authority who is a child's legal representative endangers the property of the child by mismanagement, the family court may, upon the application of any of the relatives of the child or a public prosecutor under Article 777, adjudge the loss of the right to representation on juristic acts of the child and the right to management of the child's property. This article wholly amended by Act No. 11300, February 10, 2012. Article 926. Adjudication on recovery of lost authority. When the causes mentioned in Articles 924 and 925 have ceased to exist, the court may, upon the application of the party concerned or any of its relatives pursuant to the provisions of Article 777, adjudge the recovery of the lost right. Article 927. Surrender and recovery of right of representation and of property management. 1. The person of parental authority who is the legal representative of the child may, if due reasons exist, surrender the right of representation on the juristic act of the child and the right of the management of property of the child upon the approval of the court. 2. If the circumstances mentioned in paragraph 1 cease to exist, the person of parental authority may, upon the approval of the court, recover the right which he or she has surrendered. Article 927-2. Loss of parental authority and designation, etc. of person of parental authority. 1. Article 909-2, 1, and 3 through 5 shall apply mutatis mutandis where any of the followings applies to a father or mother who has become a sole person of parental authority or both adoptive parents, excluding adoptive parents of the fully adopted child, under Article 909, 4 through 6, provided that in cases falling under subparagraphs 2 and 3, the duties of the newly appointed person of parental authority or the guardian of the minor shall be limited to the acts related to the minor's property. 1. Where the loss of parental authority has been adjudged under Article 924. 2. Where the loss of the right to representation and the right to property management is adjudged under Article 925. 3. Where the right to representation and the right to property management are surrendered under Article 927, 1. 4. Where any serious cause, such as unknown whereabouts, that incapacitates the exercise of the parental authority arises. 2. If any of the followings applies to a father or mother who has been a sole person of parental authority or one or both adoptive parents after the person of parental authority was designated or the guardian of the minor was appointed under paragraph 1, the family court may designate a new person of parental authority upon the application of one or both parents, the minor or any of the minor's relatives. 1. Where the recovery of the lost right is adjudged under Article 926. 2. Where the surrendered right is recovered under Article 927, 2. 3. Where the parental authority becomes exercisable as the father or mother whose whereabouts have been unknown is found or by any other cause. This article newly inserted by Act No. 10,645, May 19, 2011. Chapter versus Guardianship. Section 1 Guardianship for minors and adult guardianship. Subsection 1 Guardians. Article 928, Commencement of guardianship for minors. If there is no person of parental authority over a minor or if a person of parental authority is unable to exercise the right to representation with respect to the juristic acts or the right to property management for the minor, a guardian of the minor shall be appointed. This article wholly amended by Act No. 10,429, March 7, 2011. Article 929. Commencement of guardianship by adjudication on commencement of adult guardianship. If an adjudication on the commencement of adult guardianship has been made by the family court, an adult guardian shall be appointed over such person who has been adjudicated as such. This article wholly amended by Act No. 10,429, March 7, 2011. Article 930. Number of, and qualification for guardians. 1. There shall be no more than one guardian for a minor. 2. Multiple adult guardians may be appointed for an adult ward, taking into consideration all circumstances concerning the personal affairs and property of the adult ward. 3. A corporation is also eligible for an adult guardian. This article wholly amended by Act No. 10,429, March 7, 2011. Article 931, Designation, etc. of guardians of minors by will. 1. A parent who exercises parental authority over a minor may designate by will a guardian of the minor, provided that the same shall not apply to a person of parental authority who has no right to representation over juristic acts or right to property management. 2. Even after a guardian of a minor is designated under paragraph 1, the family court may, if necessary for the welfare of the minor, terminate the guardianship upon the application of the surviving father or mother or the minor and designate the surviving father or mother as a person of parental authority. This article wholly amended by Act No. 10645, May 19, 2011. Article 932, Appointment of Guardians of Minors. 1. Where no guardian of a minor is designated under Article 931, the family court shall appoint a guardian of the minor either ex officio or upon the application of the minor, any of the minor's relatives, an interested person, a public prosecutor, or the head of a local government. The same shall also apply where a guardian of a minor becomes absent. 2. Where it is necessary to appoint a guardian of a minor following an adjudication on the loss of parental authority, right of representation or right to property management, the family court shall appoint ex officio a guardian for the minor. 3. Where a person of parental authority surrenders his, her right of representation and right to property management, he, she shall, without delay, request the family court to appoint a guardian for the minor. This article wholly amended by Act No. 10429, March 7, 2011. Article 933 deleted. Less than by Act No. 10429, March 7, 2011 greater than. Article 934 deleted. Less than by Act No. 10429, March 7, 2011 greater than. Article 935 deleted. Less than by Act No. 10429, March 7, 2011 greater than. Article 936, Appointment of Adult Guardians. 1. An adult guardian referred to in Article 929 shall be appointed ex officio by the family court. 2. If an adult guardian becomes absent due to the death or disqualification, or by any other cause, the family court shall also appoint an adult guardian either ex officio or upon the application of the adult ward, any relative of the adult ward, an interested person, a public prosecutor, or the head of a local government. 3. Even after an adult guardian is appointed, the family court may appoint an additional adult guardian either ex officio or upon the application of a person entitled to file an application prescribed in paragraph 2, or an adult guardian, if deemed necessary. 4. In appointing an adult guardian, the family court shall respect opinions of the adult ward, and shall also take into consideration circumstances, such as the health, living relationship and property status of the adult ward, the occupation and experience of a prospective adult guardian, and whether a prospective adult guardian shares any interest with the adult ward, where a corporation is a prospective adult guardian, referring to whether it shares any interest with the adult ward with respect to the types or details of its business, or whether it or its representative shares any interest with the adult ward. This article wholly amended by Act No. 10429, March 7, 2011. Article 937, Grounds for disqualification as guardians. None of the following persons shall become a guardian. 1. A minor. 2. An adult ward, limited ward, specific ward, or voluntary ward. 3. A person adjudged to commence rehabilitation procedures or declared bankrupt. 4. A person who has been sentenced to suspension of qualification or heavier punishment and is in serving the term of punishment. 5. An legal representative who has been removed by the court. 6. An adult guardian, limited guardian, specific guardian, voluntary guardian or his, her supervisor who has been removed by the court. 7. A person whose whereabouts is unknown. 8. A person who has brought or is bringing an action against the ward, or his or her spouse or any of the lineal blood relatives of such person. This article wholly amended by Act No. 10429, March 7, 2011. Article 938, Right of Representation, etc. of Guardians. 1. A guardian shall become the legal representative of the ward. 2. The family court may determine the scope of the right of legal representation granted to an adult guardian under paragraph 1. 3. The family court may determine the scope of the authority of an adult guardian under which she can make decision on the personal affairs of the adult ward. 4. Where the scope of the authority of a legal representative under paragraph 2 or 3 becomes inappropriate, the family court may modify such scope upon the application of the principal, his/her spouse, any of his/her cousin or closer relatives, the adult guardian, the supervisor of adult guardianship, a public prosecutor, or the head of a local government. This article wholly amended by Act No. 10429, March 7, 2011. Article 939, Resignation of Guardians. A guardian may resign upon the approval of the family court where any just ground exists. In such cases, the guardian shall make a request to the family court to appoint a new guardian at the time with his/her submission of resignation. This article wholly amended by Act No. 10429, March 7, 2011. Article 940, Replacement of Guardians. If the family court deems it necessary to replace a guardian for the welfare of the ward, it may replace the guardian either ex officio or upon the application of the ward, any of the ward's relatives, the supervisor of guardianship, a public prosecutor or the head of a local government. This article wholly amended by Act No. 10429, March 7, 2011. Subsection 2, Supervisors of Guardianship. Article 940-2, Designation of Supervisors of Guardianship for Minors. A person entitled to designate the guardian of a minor may designate a supervisor of guardianship for the minor by will. This article newly inserted by Act No. 10429, March 7, 2011. Article 940-3, Appointment of Supervisors of Guardianship for Minors. 1. Where no supervisor of guardianship for a minor is designated under Article 940-2 and if deemed necessary, the family court may appoint a supervisor of guardianship for the minor either ex officio or upon application of the minor, any of the minor's relatives, the guardian of the minor, a public prosecutor, or the head of a local government. 2. Where a supervisor of guardianship for a minor becomes absent due to the death or disqualification, or by any other cause, the family court shall appoint a supervisor of guardianship for the minor either ex officio or upon the application of the minor, any of the minor's relatives, the guardian of the minor, a public prosecutor, or the head of a local government. This article newly inserted by Act No. 10429, March 7, 2011. Article 940-4, Appointment of Supervisors of Adult Guardianship. 1. The family court may appoint a supervisor of adult guardianship either ex officio or upon the application of the adult ward, any of the relatives of the adult ward, the adult guardian, a public prosecutor or the head of a local government, if deemed necessary. 2. Where a supervisor of adult guardianship becomes absent due to the death or disqualification, or by any other cause, the family court shall appoint a supervisor of adult guardianship either ex officio or upon the application of the adult ward, any of the relatives of the adult ward, the adult guardian, a public prosecutor, or the head of a local government. This article newly inserted by Act No. 10429, March 7, 2011. Article 940-5, Grounds for disqualification as supervisors of guardianship. None of the family members of a guardian under Article 779 shall become a supervisor of guardianship. This article newly inserted by Act No. 10429, March 7, 2011. Article 940-6, Duties of Supervisors of Guardianship. 1. A supervisor of guardianship shall supervise the affairs of a guardian, and shall file an application for the appointment of a guardian with the family court without delay in the event the guardian becomes absent. 2. If any exigent situation arises to a ward's personal affairs or property, his/her supervisor of guardianship may engage in any act or take any disposition necessary for the protection therefrom. 3. The supervisor of guardianship shall act for a ward with respect to an act in which the interests of a guardian and the ward conflict each other. This article newly inserted by Act No. 10,429, March 7, 2011. Article 940-7, Application mutatis mutandis of provisions relating to delegation and guardian. Articles 681, 691, 692, 930, 2, and 3, 936, 3, and 4, 937, 939, 940, 947-2, 3, through 5, 949-2, 955, and 955-2 shall apply mutatis mutandis to supervisors of guardianship. This article newly inserted by Act No. 10,429, March 7, 2011. Subsection 3. Duties of guardians. Article 941. Investigation of property and preparation of inventory. 1. A guardian shall, without delay, investigate the ward's property, and prepare an inventory of such property within 2 months, provided that this period may be extended with the permission of the court where any justifiable ground exists. 2. Where a supervisor of guardianship has been appointed, the investigation of property and preparation of the inventory under paragraph 1 shall become void unless conducted with the participation of the supervisor of guardianship. This article wholly amended by Act No. 10,429, March 7, 2011. Article 942. Presentation of claims and obligations by guardians. 1. Where a guardian has a claim against, or is under an obligation towards, the ward, and if a supervisor of guardianship has been appointed, the guardian shall present the details thereof to the supervisor of guardianship before he/she completes the preparation of the inventory. 2. If a guardian has been negligent in presenting a claim under paragraph 1, notwithstanding his/her awareness of his/her claim against the ward, he/she shall be deemed to have waived the claim. This article wholly amended by Act No. 10,429, March 7, 2011. Article 943. Authority of guardians prior to completion of inventory. Until a guardian has investigated the property and has completed the inventory, he shall not be entitled to exercise his authority with respect to such property, except for urgent necessity, provided that this may not be set up against a third person acting in good faith. Article 944. Investigation of property acquired by wards, etc. under blanket title. Articles 941 through 943 shall apply mutatis mutandis where the ward has acquired property under a blanket title after the guardian has assumed office. Article 945. Rights and duties of guardians on status of minors. The guardian of a minor shall have the same rights and duties as a person of parental authority with respect to the matters provided for in Articles 913 through 915, provided that he/she shall obtain the consent from the supervisor of guardianship for a minor, if the minor has such supervisor in any of the following circumstances. 1. Where he/she changes the mode of education, method of fostering, or the place of residence. 2. Where he/she entrusts the ward to a reformatory or correctional institution. 3. Where he/she revokes or restricts business permitted by a person of parental authority. This article wholly amended by Act No. 10,429, March 7, 2011. Article 946, Guardianship limited to property management. Where a person who has parental authority over a minor is unable to exercise parental authority only with respect to the right to representation on juristic acts and the right to property management, the duties of the guardian of a minor shall be limited to the acts concerning the property of the minor. This article wholly amended by Act No. 10429, March 7, 2011. Article 947, Welfare of adult wards and respect of opinions. In managing the property and protecting the personal matters of an adult ward, the adult guardian shall manage such affairs in a manner conforming to the ward's welfare considering diverse circumstances. In such cases, the adult guardian shall respect the opinion of the adult ward unless it conflicts with the ward's welfare. This article wholly amended by Act No. 10429, March 7, 2011. Article 947-2, Decisions, etc. on personal matters of adult wards. 1. An adult ward shall make a decision independently on his/her personal matters insofar as his/her conditions permit. 2. Where an adult guardian intends to isolate the adult ward in a psychiatric hospital or any other place to undergo medical treatment, etc., he/she shall obtain permission from the family court. 3. Where an adult ward is unable to give consent to the medical treatment that harms his/her body, the adult guardian may give consent thereto on behalf of the ward. 4. In cases falling under paragraph 3, if any danger, such as the possibility of death from direct results of the medical treatment or the risk of causing a substantial disability to an adult ward, exists, the adult guardian shall obtain permission from the family court, provided that he/she may make an ex post facto request for the permission if the delay in medical treatment to be caused by permission procedures is likely to endanger the adult ward's life or cause severe mental and physical disability. 5. Where an adult guardian intends to conduct the sale, rent, registration of leasehold right, creation of mortgage, termination of lease, extinction of leasehold right with respect to a building where his/her adult ward resides or the land thereof, or intends to engage in any other act corresponding thereto on behalf of his/her adult ward, he/she shall obtain permission from the family court. This article newly inserted by Act No. 10429, March 7, 2011. Article 948, Exercise of parental authority over minors. 1. A guardian of a minor shall exercise parental authority in place of his/her minor ward over a child of the minor ward. 2. The provisions concerning the duties of guardians of minors shall apply mutatis mutandis to the exercise of parental authority under paragraph 1. This article wholly amended by Act No. 10429, March 7, 2011. Article 949, Right of property management and of representation. 1. A guardian shall manage the ward's property and represent the ward in juristic acts concerning the latter's property. 2. The provisions of the proviso of Article 920 shall apply mutatis mutandis to the juristic acts as mentioned in paragraph 1. Article 949-2, Exercise, etc. of authority where adult ward has multiple guardians. 1. The family court may designate ex officio multiple adult guardians to exercise their authority jointly or severally by sharing it by the type of affairs. 2. The family court may modify or revoke ex officio designation made under paragraph 1. 3. Where multiple adult guardians need to jointly exercise their authority, if any adult guardian fails to cooperate in the exercise of required authority, such as representation of a juristic act, despite that the interest of their adult ward is likely to be infringed upon, the family court may make an adjudication substituting for the declaration of intention of the relevant adult guardian, upon the application of the adult ward, an adult guardian, the supervisor of guardianship or an interested party. This article newly inserted by Act No. 10429, March 7, 2011. Article 949-3, Acts of Conflicting Interests. Article 921 shall apply mutatis mutandis to a guardian, provided that the same shall not apply where a ward has a supervisor of guardianship. This article newly inserted by Act Number 10429, March 7, 2011. Article 950. Acts requiring consent of supervisors of guardianship. 1. If a guardian has a supervisor of guardianship, she shall obtain the consent of the supervisor of guardianship to engage in any of the following acts on behalf of the ward, or to give consent to engagement in any of the following acts by a minor. 1. A business-related act. 2. Borrowing money. 3. Taking on obligation only. 4. An act which aims at acquisition, forfeit and alteration of a right and title to immovables or important property. 5. Bringing an action to the court. 6. Consultation on acceptance, qualified acceptance or refusal of succession or division of inherited property. 2. If a supervisor of guardianship fails to give consent to an act that requires his/her consent despite the risk of infringing on the interests of the ward, the family court may, upon the application of a guardian, give permission that substitutes for the consent of the supervisor of guardianship. 3. When a guardian has done any judicial act that requires the consent of the supervisor of guardianship without obtaining such consent, the ward or supervisor of guardianship may cancel such act. This article wholly amended by Act Number 10429, March 7, 2011. Article 951. Cancellation of acquisition of property, etc. of ward by transfer. 1. Where a guardian acquires by transfer a third person's right against the ward may cancel such acquisition. 2. If a guardian has a supervisor of guardianship in acquiring a right by transfer under paragraph 1, she shall obtain consent of the supervisor, and if she fails to obtain such consent, the ward or supervisor of guardianship may make a cancellation. This article wholly amended by Act Number 10429, March 7, 2011. Article 952. Peremptory notice by other party on whether to ratify. Article 15 shall apply mutatis mutandis to cases falling under Articles 950 and 951. This article wholly amended by Act Number 10429, March 7, 2011. Article 953. Supervision over guardianship affairs by supervisors of guardianship. A supervisor of guardianship may request a guardian at any time to submit a report on the performance of his/her duties and to present an inventory of property, and may investigate the status of the ward's property. This article wholly amended by Act Number 10429, March 7, 2011. Article 954. Dispositions concerning guardianship affairs by family court. The family court may, either ex officio or upon the application of a ward, a supervisor of guardianship, any of the ward's relatives under Article 777, any other interested persons, a public prosecutor, or the head of a local government, investigate the status of the ward's property, and may order such dispositions as necessary for the management of the ward's property or any other performance of guardian's duties. This article wholly amended by Act Number 10429, March 7, 2011. Article 955. Remuneration for guardians. The court may, upon the application of a guardian, allow to the guardian a reasonable remuneration from the ward's property, taking into account the financial capacity of the ward and any other circumstances. Article 955-2. Amount of expenses due and expenses for performance of affairs. Expenses incurred by a guardian in performing guardianship affairs shall be disbursed from the property of the ward. This article newly inserted by Act Number 10429, March 7, 2011. Article 956. Application mutatis mutandis of provisions of mandate and parental authority. The provisions of Articles 681 and 918 shall apply mutatis mutandis to a guardian. Subsection 4 Termination of guardianship. Article 957. Termination of guardianship duties and account of management. 1. When the duties of a guardian have terminated, the guardian or her successor shall render an account on the property of the ward within 1 month, provided that such period may be extended upon the approval of the court if any justifiable ground exists. 2. The account mentioned in paragraph 1 shall become void unless conducted with the participation of a supervisor of guardianship, if any. This article wholly amended by Act No. 10,429, March 7, 2011. Article 958. Addition of interest and liability for pecuniary expenditure. 1. Money to be paid by a guardian to the ward or vice versa shall bear interest from the day when the account has been closed. 2. If a guardian has expended the ward's money for its own benefit, such money shall bear interest from the day when the expenditure was made, and if there are any damages incurred to the ward, the guardian shall be liable for such damages. Article 959. Application mutatis mutandis of provisions concerning mandate. Articles 691 and 692 shall apply mutatis mutandis to the termination of guardianship. Section 2 Limited guardianship and specific guardianship. Article 959-2. Commencement of limited guardianship. If the family court adjudges to commence limited guardianship, a person who is so adjudged shall have a limited guardian. This article newly inserted by Act No. 10,429, March 7, 2011. Article 959-3. Appointment, etc. of limited guardians. 1. A limited guardian referred to in Article 959-2 shall be appointed ex officio by the family court. 2. Articles 930, 2, and 3, 936, 2, through 4, 937, 939, 940, and 949-3 shall apply mutatis mutandis to a limited guardian. This article newly inserted by Act No. 10,429, March 7, 2011. Article 959-4. Rights to representation, etc. of limited guardians. 1. The family court may adjudge to confer the right to representation on a limited guardian. 2. Article 938, 3, and 4 shall apply mutatis mutandis to the right to representation, etc. of a limited guardian. This article newly inserted by Act No. 10,429, March 7, 2011. Article 959-5. Supervisors of limited guardianship. 1. The family court may appoint a supervisor of limited guardianship either ex officio or upon the application of the limited ward, any of the relatives of the limited ward, the limited guardian, a public prosecutor, or the head of a local government, if deemed necessary. 2. Articles 681, 691, 692, 932, and 3, 936, 3, and 4, 937, 939, 940, 940-3, 2, 940-5, 940-6, 947-2, 3, through 5, 949-2, 955 and 955-2 shall apply mutatis mutandis to a supervisor of limited guardianship. In such cases, Act for the ward shall be construed as Act for the limited ward or give consent to engagement in such act by the limited ward. This article newly inserted by Act No. 10,429, March 7, 2011. Article 959-6. Limited guardianship affairs. Article 681. The proviso to Article 920, Articles 947, 947-2, 949, 949-2, 949-3, 950 through 955, and 955-2 shall apply mutatis mutandis to limited guardianship affairs. This article newly inserted by Act Number 10429, March 7, 2011. Article 959-7, Termination, etc. of duties of limited guardians. Articles 691, 692, 957, and 958 shall apply mutatis mutandis where the duties of a limited guardian are terminated. This article newly inserted by Act Number 10429, March 7, 2011. Article 959-8, Protective measures related to specific guardianship. The family court may order a disposition necessary for supporting a specific ward. This article newly inserted by Act Number 10429, March 7, 2011. Article 959-9, Appointment, etc. of specific guardians. 1. The family court may, by a disposition ordered under Article 959-8, appoint a specific guardian to support, or to act for, a specific ward. 2. Articles 930, 2, and 3, 936, 2, through 4, 937, 939, and 940 shall apply mutatis mutandis to a specific guardian. This article newly inserted by Act Number 10429, March 7, 2011. Article 959-10, Supervisors of specific guardianship. 1. The family court may appoint a supervisor of specific guardianship either ex officio or upon the application of the specific ward, any of the relatives of the specific ward, the specific guardian, a public prosecutor, or the head of a local government, if deemed necessary. 2. Articles 681, 691, 692, 932, and 3, 936, 3, and 4, 937, 939, 940, 940-5, 940-6, 949-2, 955, and 955-2 apply mutatis mutandis to a supervisor of specific guardianship. This article newly inserted by Act Number 10429, March 7, 2011. Article 959-11, Rights to representation of specific guardians. 1. The family court may adjudge to confer the right to representation on a specific guardian to support a specific ward, setting the period and scope thereof, if deemed necessary. 2. In cases falling under paragraph 1, the family court may order a specific guardian to obtain the consent of the supervisor of specific guardianship to the exercise of his/her right to representation. This article newly inserted by Act Number 10429, March 7, 2011. Article 959-12, Specific guardianship affairs. Article 681, the proviso to Article 920, Articles 947, 949-2, 953 through 955, and 955-2 shall apply mutatis mutandis to specific guardianship affairs. This article newly inserted by Act Number 10429, March 7, 2011. Article 959-13, Termination, etc. of duties of specific guardians. Articles 691, 692, 957, and 958 shall apply mutatis mutandis where the duties of a specific guardian is terminated. This article newly inserted by Act Number 10429, March 7, 2011. Section 3 Guardianship Contracts. Article 959-14, Meaning, Method, etc. of contracting guardianship. 1. The contents of a guardianship contract shall be to entrust all or some of a person's affairs related to property management and protection of private matters to another person where the person is in the state of lacking the capacity to manage the affairs due to a disease, disability, old age or by any other cause, or to prepare for the possibility of falling under such situation, and to confer the right to representation with respect to the entrusted affairs on another person. 2. A guardianship contract shall be entered into in an authentic deed. 3. A guardianship contract shall take effect at the time the family court appoints a supervisor of voluntary guardianship. 4. In implementing and managing a guardianship contract, the family court, a voluntary guardian, a supervisor of a voluntary guardian, etc., shall respect the wishes of the principal to the greatest extent possible. This article newly inserted by Act No. 10429, March 7, 2011. Article 959-15. Appointment of supervisors of voluntary guardianship. 1. Where a guardianship contract is registered and the principal is deemed in the state of lacking capacity to manage his/her affairs, the family court shall appoint a supervisor of voluntary guardianship upon the application of the principal, his/her spouse, any of the first cousins or closer relatives, the voluntary guardian, a public prosecutor, or the head of a local government. 2. In cases falling under paragraph 1, where the family court appoint a supervisor of voluntary guardianship upon the application of a person who is not the principal, it shall obtain the consent from the principal in advance, provided that this shall not apply where the principal is unable to declare his/her intention. 3. Where a supervisor of voluntary guardianship becomes absent, the family court shall appoint a supervisor of voluntary guardianship either ex officio or upon the application of the principal, any of his/her relatives, the voluntary guardian, a public prosecutor, or the head of a local government. 4. Where deemed necessary even after a supervisor of voluntary guardianship is appointed, the family court may appoint an additional supervisor of voluntary guardianship either ex officio or upon the application of a person entitled to file an application under paragraph 3. 5. Article 940-5 shall apply mutatis mutandis to a supervisor of voluntary guardianship. This article newly inserted by Act No. 10429, March 7, 2011. Article 959-16, Duties, etc. of supervisors of voluntary guardianship. 1. A supervisor of voluntary guardianship shall supervise the affairs of the voluntary guardian and file a periodic report thereon to the family court. 2. If deemed necessary, the family court may require a supervisor of voluntary guardianship to file a report on the affairs related to supervision, and to conduct an examination on the affairs of the supervisor of voluntary guardianship or on the status of the principal's property, or to take other necessary measures with respect to the duties of the supervisor of voluntary guardianship. 3. Articles 940-6, 2, and 3, 940-7 and 953 shall apply mutatis mutandis to supervisors of voluntary guardianship. This article newly inserted by Act No. 10429, March 7, 2011. Article 959-17, Restrictions, etc. on commencement of voluntary guardianship. 1. If a voluntary guardian is a person who falls under any subparagraph of Article 937 or otherwise a person who has committed a significant misdeed or a person in whose case any ground for his/her inappropriateness for the affairs set forth in the guardianship contract arises, the family court shall not appoint a supervisor of voluntary guardianship. 2. Where an appointed voluntary guardian commits any significant misdeed or otherwise falls under any ground inappropriate for his/her affairs, the family court may remove the voluntary guardian from his/her position upon the application of the supervisor of voluntary guardianship, the principal, any relative of the principal, a public prosecutor, or the head of a local government. This article newly inserted by Act No. 10429, March 7, 2011. Article 959-18, Termination of guardianship contracts. 1. The principal or a voluntary guardian may withdraw his/her declaration of intention by submitting a document certified by a notary public, anytime before a supervisor of voluntary guardianship is appointed. 2. If a supervisor of voluntary guardian has already been appointed, the the principal or the voluntary guardian may terminate the guardianship contract with the permission from the family court only when a justifiable ground exists. This article newly inserted by Act Number 10429, March 7, 2011. Article 959-19. Extinction of rights to representation of voluntary guardian and relationship with third person. The extinction of the right to representation of a voluntary guardian shall not oppose against a bona fide third person unless it is registered. This article newly inserted by Act Number 10429, March 7, 2011. Article 959-20. Relationships between guardianship contract and adult guardianship, limited guardianship and specific guardianship. 1. Where a guardianship has been registered, the family court may adjudicate on adult guardianship, limited guardianship or specific guardianship upon the application of a voluntary guardian or a supervisor of voluntary guardianship, only when such guardianship is particularly necessary for the principal's interest. In such cases, the guardianship contract shall be terminated at the time the commencement of adult guardianship or limited guardianship is adjudged for the principal. 2. If the principal is an adult ward, limited ward or specific ward, the family court shall, if it intends to appoint a supervisor of voluntary guardianship, adjudicate on the termination of the former adult guardianship, limited guardianship or specific guardianship, provided that where the continuation of adult guardianship or limited guardianship is deemed particularly necessary for the principal's interest, the family court shall not appoint a supervisor of voluntary guardianship. This article newly inserted by Act Number 10429, March 7, 2011. Chapter V. Family Council. Article 960. Organization of Family Council. A family council shall be organized when any circumstances which require a resolution of family council in accordance with the provisions of this Act and any other acts exist. Article 961. Number of family council members. 1. Members of a family council shall be not less than 3 and not more than 10 in number. 2. A family council shall have one representative, who is elected by mutual votes among members of the family council. 3. The representative mentioned in paragraph 2 shall legally represent the family council concerning activities in a litigation or other acts directed to outsiders. Article 962. Designation of family council members by person of parental authority. A person of parental authority who may designate a guardian, may designate members of a family council for minor. Article 963. Election and appointment of family council member. 1. Members of a family council shall be appointed by the court from among the relatives pursuant to the provisions of Article 777 or the persons who are in any special relation to the person concerned, upon the application of the person concerned, his or her legal representative or any of the relatives pursuant to the provisions of Article 777 or the party interested, provided that this shall not apply to the case where members of a family council have been designated in accordance with the provisions of Article 962. Less than amended by Act Number 7427, March 31, 2005 greater than. 2. A person who is entitled to file an application to the court pursuant to the provisions of paragraph 1 may submit a statement of his opinion concerning the number of members of the family council and their appointment. Article 964. Ineligibility for membership of family council. 1. A guardian may not become a member of family council for the ward until the account of guardian's management has been completed. 2. The provisions of Article 937 shall apply mutatis mutandis to the members of family council. Article 965. Standing family council for person lacking legal capacity. 1. A family council for a minor, an incompetent or a quasi-incompetent shall continue to exist until the time when the cause of incapacity has ceased. 2. When a vacancy in the position of family council member as referred to in the preceding paragraph has occurred, the court shall fill up such vacancy ex officio or upon the application. Article 966, Convocation of Family Council. Family council shall be convoked by the family court upon the application of the person concerned, his or her legal representative, spouse, any lineal blood relatives, member of family council, the party interested or prosecutor. Less than amended by Act No. 4199, January 13, 1990. Act No. 7427, March 31, 2005 greater than. Article 967, Method of decision by family council. 1. Decisions of family council on the matter concerned shall be made by an affirmative vote of the majority of the members. 2. A member interested in the matter mentioned in paragraph 1 shall be excluded from voting. 3. In cases where a decision has been made in writing by an affirmative vote of the majority of family council in place of a decision of family council, the person who is entitled to demand the convocation of family council in accordance with the provisions of Article 966 may apply to the court for its revocation within 2 months. Article 968, Expression of opinion at family council. The person concerned, his or her legal representative, spouse, lineal blood relative, or collateral blood relative within the fourth degree of relationship may present and express his or her opinion at a family council. Less than amended by Act No. 7427, March 31, 2005 greater than. Article 969, Court decision to be substituted for decision of family council. If it is impossible for family council to make a decision or family council fails to make a decision, the person who is entitled to demand the convocation of family council may apply to the court for a decision which will substitute for a decision of family council. Article 970, Surrender of membership from family council. A member of family council may, if valid reasons exist, surrender the membership of family council upon permission of the court. Article 971, Dismissal of family council member. 1. If any unjustifiable act has been committed against the duty of the member of family council and there is any other improper reason, the court may, ex officio or upon the application of the person concerned, his or her legal representative, or any of the relatives of the person concerned pursuant to the provisions of Article 777, or the person interested, replace or dismiss the responsible member of family council. 2. In cases where the count deems it appropriate, the court may ex officio or upon the application of the person concerned, his or her legal representative, or any of the relatives of the person concerned pursuant to the provisions of Article 777 or the party interested, increase the number of the members of family council and appoint them. Article 972, Decision of family council and actions of demurrer thereto. A person who is entitled to demand the convocation of a family council may within 2 months after a decision of family council file an action in the court to contest such decision. Article 973, Duties of members of family council to manage with care of good manager. The provisions of Article 681 shall apply mutatis mutandis to a member of family council. Chapter 7 Support. Article 974, Duty to furnish support. Relatives falling under each of the following subparagraphs shall be under a duty to furnish support to each other. 1. Among lineal blood relatives and their spouses. 2. Deleted. Less than by Act No. 4199, January 13, 1990 greater than. 3. Among any other relatives, limited to cases where they share living accommodations. Article 975, Duty to furnish support and ability of living. A person under duty to furnish support shall perform her duty only where the person entitled to receive support is unable to support himself or herself by his or her own financial resources or labor. Article 976, Order to furnish support. 1. In cases where there exist several persons under duty to support, and no agreement has been reached between the parties concerned with respect to the order in which they are to furnish support, such order shall be determined by the court upon the application of the parties concerned. In cases where there exist several persons entitled to get support, and the financial capacity of the person under duty to furnish support is insufficient to support all of them, the same shall apply. 2. In cases of paragraph 1, the court may select and designate several persons under duty to furnish support, or entitled to get support. Article 977, Extent and method of support. If no agreement has been reached between the parties concerned with respect to the extent and method of support, the court may, upon the application of the parties concerned, determine such matters, taking into account the living standard of the person entitled to get support, the financial capacity of the person under duty to furnish support, and any other related circumstances. Article 978, Alteration or revocation of support relation. If, after an agreement has been reached between the parties concerned, or a court decision has been rendered with respect to the order of persons under obligation to support or persons entitled to get support, or to the extent and method of support, any change has taken place in the circumstances, the court may revoke or alter the agreement or the decision upon the application of the parties concerned. Article 979, Prohibition of disposition of claim for support. The right to be supported may not be the subject of disposition.